All right. Good morning, good afternoon, everybody, depending on which part of this beautiful country you're on. My name is Charlie Gipple. I'm the owner of CG Financial Group. Folks, first question for you, the veterans on the phone that have been on many of these webinars, you know what I'm about to ask. How is my audio and video? Am I coming through okay? Can you see me? Can you hear me? So down on the lower right-hand side, at least on my end, it's lower right-hand side. Can you see me and can you hear me okay? Punch that into the question and answer pane. Yes or no, or I can't hear you, or man, you are one ugly sucker. Whatever you want to say, just let me know that you are hearing me and seeing me somehow, because we're going to have a blast here. I'm going to pull up my participants, see who all is on. Yes, David, I knew you would comment. By the way, absolutely thrilled to have you on. He commented in regards to my physical appearance. All right, we have an excellent group. This is going to be fun, folks. Before we get started, I'm going to go over 3 housekeeping items, actually 4. The first housekeeping item is this, is participate throughout this presentation, ask questions, give your feedback. I will not be able to get to all of them. As my webinars have grown over the years that my company's been in existence, I've learned that it's just harder to stay on top of all the questions and answers, but the chances are decent that I'll address your concern or question if you post it in the same pane that I just conditioned you to utilize, and that's a questions and answer pane. Housekeeping item number 1, participate. Housekeeping item number 2, please stick around and fill out the evaluation at the end, because I really do look at that information, such as, is this a webinar that you would like me to do on a nationwide basis for the agents, clients of CG Financial Group? I've done this a couple times now, one with Social Security, one with long-term care. And we had like a couple hundred registrants on both of them, I want to say. We had 200 on one, I know. So is this a webinar? Don't tell me now. Wait until you see the webinar. Is this a webinar that you would invite your clients to ultimately, to where my job is to make sure that those clients are driven back to you and they are warm by the time we get done talking about this? Well, what are they going to talk with me about when it comes to protecting assets? Well, life insurance, well, annuities, well, long-term care, because I tease on all 3 of these things throughout the presentation. Life insurance, for instance, if you're a doctor and if you get sued, if you're in the state of Florida, is that life insurance cash value accessible by the creditors? No, it's not. That's a life insurance teaser, as well as some of the stuff I'm going to talk about here in a bit. That's bullet point, actually bullet point number 2. I'm going off the cuff here, which can be dangerous. Bullet point number 3 is, folks, annuities are skyrocketing right now. Depending on what state you're in, you can guarantee your clients, say 4.5% for 5 years, somewhere in that area. For 3 years, upwards of close to 4%, 3.5% to 4%. For those clients, the trillions of dollars sitting in certificates of deposit, averaging 0.5% for 5 years, why would they not go that route? Annuity triplers for long-term care, Mrs. Client. You put your money into this annuity, you get multiples of the interest rate that you were getting, but on top of that, you have a long-term care pool that is immediately triple what you put in. So whether it's the annuity tripler, the long-term care annuities, whether it's indexed annuities or multi-year guaranteed annuities, they're flying off the shelves. My pending business, what's in the pipeline, is 3 times larger than it has ever been in the existence of my company. 3 times larger. Granted, I've been in business for 3.5 years, not 50 years, but I would say that's pretty good. You want some more tangible statistics? I'll give you this. Multi-year guarantee annuities are up 80% second quarter this year versus the second quarter 2021, up 80% industry-wide, I'm talking. Second quarter this year versus first quarter this year, up around 80% as well. They're flying off the charts, folks, but you have to know which products are good, which products are with companies that maybe are not favorable. That is where you work with somebody like me. You know, when you work with my company, you're working with me, the owner of the company. When you work with CG Financial Group, you work with me. Now, for some of you, that may be a disadvantage. I don't know. I'll let you be the judge of that. But I've been there, done that with a lot of this stuff. And I'm finding that is what agents appreciate, because if you miss out on a sale because of me, then I miss out on a sale as well. It's just a different mentality. But you have an army of about 50 people, a back office of about 50 people that process your apps when they come in. Annuities, life, long-term care, automation, which actually brings me to my third topic here we're going to talk about next week. Automation, iPipeline, iGo, eApps. You will never be out product when you work with my company, because not only do we have the 200 or so insurance companies, we have the technology to pinpoint for your specific client which product is the best for their scenario. Which brings me to bullet point number 3, formerly, but is now bullet point number 4, because I'm going off the cuff. Webinars. So last week we had a pretty heavily attended webinar on Charlie's favorite annuities, life, and long-term care. I think I probably went over very high level, 12 different products maybe. Talked about, hey, this annuity has an 8% cap guaranteed forever. 8% cap guaranteed. This annuity has a 9% cap, and I'm talking about S&P 500 annual reset. This annuity has a 12% cap with a 1% buy-up fee, for example. So went over all of these teasers, and a lot of people came back in the evaluations who stuck around for the evaluations. Again, I emphasize, please fill out the evaluation at the end of this, and said, I like this. This was the best one yet. So if you want that replay, let me know. Assuming you're not my competition on the phone, which I get a lot, which is okay. That's fine. I'm just not going to send you the recordings of the previous webinars. Next week, you do not want to miss next Thursday's webinar, and that is practice management around this. Then we're going to get into the good stuff around this. So on Saturday, some of you saw this video I posted on LinkedIn. I was working out and I see these emails coming in, and the emails all started because people were, what does my guy David say? Completely off topic to think about. Have you thought about becoming a CE course provider? I believe your webinars should be CE because they are that good. I promise that wasn't a plant. I have David, but I know there are a lot of formalities, right? But after COVID, maybe those formalities are not so much because it's not so mandatory to be in person, to have people sign in, to have people sign out. I could probably pick your brain on that. And CE, that brings in a lot of folks when it comes to these webinars. So I'm working out, and these emails are popping in. And the beginning of the email train that I got was people were registering for Zoom calls. Heck, this is one of the Zoom calls, but also clients were registering for Zoom calls. Well, that's not breaking news, Charlie, so tell me more. But then I'll get an email coming in from my constant contact email service saying, your automated email campaign has begun because somebody started this process. The process was triggered by somebody filling out just one thing, a Zoom webinar, which then fed into my email database, which then led to an automated email campaign, which then fed into my CRM, which is Smart Office, eBix Smart Office. You get access to this for a very low cost through me, by the way. Because what happened is, because of this train right here, the technology speaking to each other, this person was entered into basically every area of technology that I have in my business. My business was working while I was not. I was screwing around in the gym, right? Somebody goes to my website, as you may have, fill out the contact form. Yes, I would like to see some of your articles that you write. And by the way, if you haven't been to my website, go out there, read some of those articles. You'll see a pop-up. Especially the agent page, you'll see a pop-up, and not the type of pop-ups that some of you may get on your computers. That doesn't happen here. You get a pop-up, and that pop-up says, are you an agent? Do you want updates as time goes by? Give us your name, your email address. Boom, that triggers all of this stuff that I'm talking about. How do I do that? We're going to talk about that next week. So that's next week's webinar. So let's get into it. Any questions, comments, concerns so far, as I kind of wet your whistle, so to speak, on the content of this webinar? Then we're going to step back, go over the agenda after I do this for about 5 minutes. Then we're going to dig into the nitty gritty, kind of digging into the nitty gritty right off the bat here. But I want to show you the context of this asset protection conversation and ask questions as we go. Also contribute as we go, if you like. So here we have Jim. Jim owns a bunch of rental property. Jim is a Florida resident. That's relevant. What state? All of this is state-based. Who has tenancy by entirety? Depends on what state. How are LLCs treated from an asset protection standpoint? Depends on what state. Are annuities and life insurance cash value? Is that protected? Depends on what state. What about IRAs versus Roth IRAs? Depends on what state. But he's a Florida resident and he has a C corporation. And that C corporation has a bunch of apartments, let's say. He's also got cash in there, but he also has his own personal assets. He has a brokerage account. Maybe he's got a gazillion bucks in that sucker. He's got his personal residence. He has a boat. Yes, I chose the pirate ship because Jim is a legend. He doesn't have a boat. He's got a pirate ship. That's a legend there, right? So what happens when this happens? So because of a faulty stairs in one of his apartments, somebody falls and breaks their neck. And let's say the person passes away. A lawsuit happens. What assets, first question, what assets are at risk to Jim? What assets are at risk to Jim because within one of those apartments down there, somebody fell, broke their neck, and the family is suing like crazy. Generally, what assets are in the crosshairs of the opposing attorney? My guy David can't be the only one participating, folks. What or do you not know? Just tell me if you don't know as well. Just a little participation feeds the fire of everybody. Gets me fired up, that's for sure, as well as the 2 gallons of coffee here. Everything in his name. Not usually. So David is right. Certainly what is in the crosshairs of this new creditor that they have, the lawsuit, right, is the assets within the C corporation, because that was within his company work. Now, these are called inside creditors. It's very important that we talk about inside creditors versus outside creditors. This example has to do with inside creditors within the workings of the corporation, or if it's a limited liability company, within the workings of that, those are inside creditors that can only go after the assets of that company. Those are inside creditors there. And that is why we create, one of the reasons we create C Corps, S Corps, or even best yet, from an asset protection standpoint, a limited liability company to shield our personal assets up there, the home, his brokerage account, his pirate ship. That is why we do this, to keep that liability quarantined off, to keep that liability contained, right? Now, here's a caveat, however, folks. Here's a caveat. What about professionals like doctors, like CPAs, like attorneys, professionals providing personal services, specialized personal services, to where the competence of that attorney, that CPA, that doctor, think of OBGYN doctors. I'm going to talk about this here in a bit. OBGYN doctors. Is it contained within their C Corp? Is it contained within their limited liability company? Yeah, that's right. As long as it is, let me step back. So this is a great point. As long as it is not a sham corporation and all the books and records are separated. What is he talking about? If it's a sham corporation, many of you may have heard this, piercing the corporate veil. There are a lot of different things that can make it a sham corporation, right? But if this corporation was set up basically just as kind of a shield and that's it, what can happen? The corporate veil can be pierced, which means, you're going to hear this on the news someday if you haven't already, I promise, which means all those other assets above, except his homestead, are accessible by his newfound creditor, right? Are accessible by his newfound creditor. Now, what was I talking about with professionals? Professionals, doctors, attorneys, lawyers, financial advisors. I'm a financial advisor. Insurance agents. I'm an insurance agent. You might as well forget the C corporation. You might as well forget the LLC. I say that tongue in cheek because you still want those, in case, employee lawsuit or whatever, employee lawsuits within the confines of the C Corp or LLC. You still want that, even if you're a financial advisor. But your practice of screwing up somebody while in practice, a surgeon screwing up on surgery, it's outside creditor treatment, basically, right? They can get access to your boat, they can get access to your brokerage accounts, but in the state of Florida, they cannot get access to your homestead. Why is that? Because of homestead rules that we're going to talk about here in a bit. You could have a gazillion-dollar house. They do not get access to your house. That's why I put that house up there. We're going to talk about homestead exclusions here in a bit. So what do we have? What do we have? Yep, employee lawsuits. That's right. David, that's right. For advisors, an LLC, because most of you are, an LLC and a corp has protection only for employee lawsuits and chargeback debt roll-up protection. So again, you still want that, but don't think that if you rip off a client, not that any of you are planning on doing that, I'm sure, that your assets are protected. Well, heck, I did that within my LLC. No, a doctor that screws up on delivering a baby, which is tragic, right? OBGYNs. And I'm going to show you some statistics here. You can bet that that person is held personally liable, which is why doctors have what? Which is why insurance agents have what? I'm not going to answer that. I'll let you guys answer that. And then I'll come back and tell you what everybody answered. All right, so let's go. E&O, boom. That's right. So let's go to the other scenario. Here we have Jim, the legend that owns a pirate ship. Jim owns rental property within a C corporation. By the way, I didn't mention this earlier, but he owns 60% of that C corporation. He owns 60% of this C corporation. Yeah, licenses to be held liable for actions. So yeah, that's something I haven't communicated much. If you need to get a license for something, chances are you're personally liable. There are probably exceptions to that. I don't know of any exceptions, I guess. But yeah, if you need to get a license, you're basically personally liable. Now, here is the scenario. It's Labor Day coming up. Labor Day's coming up, baby. So here's what Jim does on Labor Day. He lets somebody, let's say it's Charlie, borrow his boat, his pirate ship, after over-serving Charlie, and Charlie crashes into somebody else and Charlie dies. What does Charlie's family do? Because Charlie had the party at Jim's house. I'm not a big partier. I just like to live vicariously this way. Had a party at Jim's house. It was Jim's boat. What happens? What assets then for Jim are in the crosshairs of the newfound creditor, Charlie's family? What assets are in the crosshairs? Obviously, the pirate ship, whatever is left of the pirate ship, obviously the personal assets I'm talking about here, right? The brokerage account. And by the way, think about this. So think about this. Dangerous assets. What if this conversation would be shortened if Jim had his pirate ship, for example, set up within a what? Who owned that pirate ship? Who owned that pirate ship? What would it do if, say, a limited liability owned that pirate ship? This is probably a bad example because Jim is liable for a whole lot there. He overserved, but generally, so a state protection strategy is you have dangerous assets, liability-driven assets. You have benign assets like brokerage accounts. What if LLCs own this stuff? Why LLCs? Why is Charlie not talking about C corporations? Because that leads me into this. There's a third crosshair here, and that third crosshair is Jim owns 60% of the C corporation. He owns 60% of the stock in that C corporation. That is a personal asset of his. This is where C corporations and limited liability companies set up correctly in the right state that treats limited liability companies favorably, multiple member limited liability companies. This is where LLCs and C corporations diverge right here. This is the difference. By the way, folks, am I giving you talking point? We haven't even gotten into the good stuff. Am I yet giving you talking points that you can share with clients, whether they're a doctor, whether they own real estate, which a lot of people do, rental properties, right? Somebody falls and breaks their neck, or somebody with just a heck of a lot of assets like boats, dangerous stuff, boats, guns, wave runners. Am I giving you talking points yet? Tell me yes or no. Yes or not yet. All right. I did get one yes, but a little over my head. And it's intended to go fast. I'm giving you a lot here within an hour-long period of time, but I promise you that somewhere down the road, you'll think, I think I heard something like this from Charlie. Now, but stock versus members' interest in an LLC. So this Charlie's family that is suing Jim can actually go after his 60% of the company, can go after his shares of stock. And what can happen is he can be the new majority owner of the company eventually, right? The judge can either enter the stock to be liquidated, transferred, what have you. But Charlie's family is now the owner of the stock. What can they do? They can liquidate the company because they're a majority owner. What if instead this down here, so all this disappears then in that case? It's not piercing the corporate veil. No, it is just having the creditor get access. I'm in California. Yep, California, different rules. It is about the creditor getting access to the company as well. So what I'm talking about, by the way, is outside creditors. Now, what if this was a limited liability company? If this was a properly set up limited liability company, there's very little that can be done. If that limited liability company was set up correctly in the right state, where that state says the sole remedy against the limited liability company is basically, this is the way it works, is basically where the judge has a charging order that says any distributions, because that's what happens from LLCs, it's member distributions, I guess you would call it. There are no shares of stock. There are no shares of stock. It's just members' interest. You can't transfer those member interests. You can't sell those member interests, at least if you're the creditor. All that you can do is latch on to the distributions that will be coming out of that LLC. Now, here's what's interesting. If the LLC says, we're not distributing anything, what happens? This is, in a way, kind of humorous. What happens is no money goes to the creditor until there is something distributed. What does go to the creditor? What do you think goes to the creditor, even though that creditor, me, my family, the people that are filing the lawsuit against that limited liability company, what is going to the creditor? What do you think it is? An IOU, that's certainly it. But what else? A K1, a K1. We're talking phantom income. Think of a K1 as a 1099. It's not. In the LLC world, it's generally, it's K1s, right? So phantom income, you haven't gotten the income, but hey, you're taxed on it. So how aggressively, this third crosshair, how aggressively do you think that the plaintiffs, that the creditors are going to get behind that third crosshair versus if it was otherwise those nice juicy shares of maybe a multi-million-dollar company? LLCs set up correctly in the right state, they're a beautiful thing. And I'm not an attorney, folks. I can't set this stuff up, but I know people that can. All right, a little bit about me. I think most of you know about me. You know, when you work with me, you work with me. And when you work with my company, you work with me. I was in the corporate world, an executive of various insurance companies for 20 years or so. 3.5 years ago, I opened this IMO with the intent of providing agents, financial advisors, registered reps, all the above, with annuities, life, long-term care expertise, as well as estate tax, estate tax planning, long-term care planning that is unmatched in the industry, which may sound bold, but I'm an old guy. I've been there, done that. You're not dealing with a 25-year-old, right? And it's not that I'm smart. It's just that I've been here a long time. And I've been with various companies that have allowed me to do a lot of things. So that's a little bit about me. I opened this organization 3.5 years ago and already have around 300 agents that are working with my company. This year, my company will do around 30 million in annuities business. probably $500,000 in life business. Pretty darn good considering only 3.5 years in the business. Annuities, life, and long-term care. I am your IMO if you're an independent agent. So that's about me. Cross that one off. 2 risks that can destroy wealth. The first risk being taxes. Going to talk a little bit about taxes. Also going to talk about potential legal solutions to that second risk. That second risk being what we've been talking about, to kind of tease you earlier. It was a long tease, but that is creditors. So going to talk about taxes, going to talk about creditors, those 2 risks that can destroy people's wealth. But then we're going to talk about potential legal issues like ownership structures, trusts, a little more on LLCs. Also going to talk about financial solutions. I'm kind of saving the best for the last. And again, make sure you stick around for the evaluation, because I want to know if this is a presentation. I would slow it down a lot, and I would talk a lot slower, just so you know, a lot less intense, so to speak, a lot more in layman's terms for your clients. Let me know in the end if you want to be on the list for potentially inviting some of your clients. Here's a scenario that I had recently. And a lot of people own real estate and they're selling real estate for elevated values, right? Does anybody know what the median nationwide price of a house is in the United States today? What's the median price of a home? Yeah, 450 to 500. Yeah, I think it's around $450,000. So home prices have skyrocketed, right? It's another part of inflation that we're dealing with. So you're going to run into this a lot. And this is a scenario, a real scenario. You know, I probably made MDRT last year, right? I do a lot of personal production myself, but that's my side job. That's the laboratory where I test stuff to come to you guys. So I do a lot of personal production just kind of on accident. But here is what one of my clients came to me with recently. She says, Charlie, I am selling my home for $1 million in Denver. I said, okay, what do you have in it? What's your cost basis? I don't say that to clients, but what do you have in it? 250,000. Okay, so you have $750,000 in gain in that property. She's lived in that home for like 20 years. $750,000 in gain. So folks, here's the first question. How much capital gains is going to be taxed? How much capital gains is going to be taxed? She bought the home for $250,000, sold it, and you'll come across this, I promise. If you are a trusted advisor for your clients that are selling real estate, you will come across this, as well as a bunch of other questions I'll get into. Bought it for $250,000, sold it for $1 million. How much of that $750,000 gain, and she's single, by the way, how much of that $750,000 gain is subject to, capital gains tax? 500,000. That's right. For single, there is a $250,000 exclusion, assuming that she has lived in that house for at least 2 years out of the previous 5 years. If she was married, which is a strategy, she's dating somebody, but I won't go there. If she was married, $500,000 would be the exclusion. So here is what she says to me. She says, okay, so that on top of my $40,000 in other income, is that going to bump my $40,000 in income, true earned income, not earned, but income subject to income taxation? What tax bracket is she going to be in? Let me ask you this. What tax bracket for this year is she going to be in, because she sold a house for $500,000, has $40,000 coming in as income? What tax bracket is she going to be in from a income tax standpoint? Everybody's got it wrong. Everybody's got it wrong. But you're right in getting it wrong. So here, because this is complicated, but I'll tell you, and this is a real applicable practical scenario here. She has adjusted gross income, whatever her adjusted gross income was, right? A part of that is the capital gains of 500,000. Another part is the 40,000 going in. She gets all of her adjustments and all that, her adjustments from income, her standard deduction, all of that good stuff. But in the end, let's say she has taxable income. Let's simplify it and say $540,000. Common sense would say, well, Charlie, that means that she is single filer. She is going to be in the 37% tax bracket. By the way, let's say that she was. Does that mean that all of her $540,000 is taxed at 37%? If she was, is that what that means? You take $540,000 times 37%. If she was, is that what that means? So that's a question for you guys. No, it's not what that means. These are called marginal. Technically, her first 10,000 is taxed at 10. Her next is taxed at 12. The next, whatever, 40,000 is taxed at 22. In the end, you have the effective tax rate, right? Which also includes all the deductions and all that. The effective tax rate, maybe 10%, 15%, whatever it is. But to get to my original question, she is in the income tax bracket of 12%. She's in the income tax bracket. She asked me this. I said, no, you're in the income tax bracket, 12%. That's not what my CPA says, or what my tax person says, not a CPA technically. I said, I promise you. I'll go back and I'll double check, but I promise you. Here is the way it works. You have $540,000 in taxable income. It's kind of like FIFO and LIFO. First, what you do is you calculate how much is subject to income taxes. That's $40,000, right? She is in the 12% tax rate for her income taxes. That's right, Matthew. But then in addition to that, you pile on that $500,000, and that's where you come over for her separate capital gains tax, which is based off of the 20% capital gains tax rate. That's the order of calculation there, right? That's the order of calculation that a lot of people don't know about. I bring all of that up. Capital gains is 20% plus 3.8% technically Medicare surtax. I promise you, you will run into that eventually. But actually, before I go there, a quick note on estate taxes. You're going to see me talk a lot more about estate taxes because this exemption, as in, you know what, if I have a single person, they need an estate over 12 million before I even open my mouth about estate taxes. Or if they're married, 24 million. And then over that, yes, it's 40%. So for example, so a lot of people are saying, I don't even want to hear about it. You will start to hear about it, I promise you. But so what that means is if somebody has $20 million as an estate, they pass away, roughly all of that $8 million is taxed at 40%. Technically not, but roughly all of that $8 million above the exemption is taxed at 40%. So there's a $3.2 million tax that's going to be owed. By the way, folks, in that example, what might be a good situation? What might be a good situation or a good solution to take care of that $3.2 million tax eventually? What would be a good solution for that? Then I'm going to add on to your comment back. What would be a good solution to that $3.2 million tax that is going to be coming in at the death of this owner? Boom, life insurance. I would take it a step further to talk about asset protection. Life insurance within an irrevocable life insurance trust. Life insurance within an irrevocable life insurance trust, owned by an irrevocable life insurance trust. Why is that? Let's step back a second. Thought-provoking stuff here I'm trying to bring out. Okay, so when she passes away, if her estate was $20 million, but there's a life insurance policy owned by her, she was also the insured because she was the owner. What's included in her estate? What's included in her estate? Keep it separate from the estate. That $3.2 million life insurance policy. Oh, Charlie, life insurance, especially if the beneficiary is somebody else other than her, life insurance is excluded from the estate, especially if it's going to Jimmy Doe, her son. No, it's in the owner's estate, and life insurance proceeds are included in the owner's estate. People don't realize that. So technically, it's a $23.8 million estate that she is passing on to little Jimmy Doe, even though he's a beneficiary. It all comes back to the owner, right? Conversely, so what I just explained is the reason for irrevocable life insurance trust. It's a separate entity, by the way, protected from creditors because it's a completely separate entity, and it's excluded from the estate. So what happens is that ILIT is going to say that Jimmy Doe is the ultimate beneficiary, and boom, you have a complete offsetting of that $3.2 million estate tax there. I kind of commingled a lot of different concepts there, but I hope you're following there. Yeah, the 3-year rule on ILITs. Yep, not going into that. Okay, so my client, awesome lady, single lady. I said, but that's not it. You just need to be aware of what's going to happen to your Social Security. Remember how I said that 500,000 plus 40,000, it all goes into adjusted gross income. And then it trickles down to taxable income, $540,000 here. What does that do to her Social Security benefit? Well, the Social Security Administration says it depends on how high her provisional income is. What is provisional income? That's her adjusted gross income. Call it 540,000 to simplify it, plus 50% of her Social Security benefits, a couple grand a month. Let's call it an additional 10,000 a year. So we're up to 550,000 now. Plus non-taxable interest, municipal bond interest, right? That's her provisional income. So I say, Bonnie, if your provisional income based off that calculation is above $34,000, in which she laughed at, as she should, she's like 550,000, then 85% of your Social Security is going to be taxed, FYI. She says, well, dang, all because I sold a house? Yeah, because you sold a house. If you're married filing jointly, 85% can be taxed if you have that provisional income over $44,000. I did this for consumers a while back for one of my agents. I don't know if he's on the phone, my guy, talking to a bunch of real estate folks. And I got a lot of questions on this. Like, wow, 85% of your Social Security is taxed? Yes. How do we prevent all this? That's the goal to all of this, while sheltering those assets in the case you get sued, which we're going to dig into more later here. What about IRMA, which is income related monthly adjustment amount for Medicare purposes? Hey, Bonnie, 2 years from now, because that's the way Medicare looks at it, your Medicare premium is not going to be $171. Well, it's right here, $170 anymore. 2 years from now, they're going to look at your 2022 taxes, and they are going to say, you're actually above, as a single person, individual tax return, above $500,000. For that year, you are going to be paying $578 per month for your Medicare. The punchline here with all of this is minimizing the adjusted gross income. What are strategies for, now, Bonnie, she's so far out there with the sale of that house, and this year, she's so far out there, there's very little that I can do. But minimizing that adjusted gross income, cash value life insurance, capital gains offset. So I told her, I said, that real estate, you don't own, at the outset of our conversations, you don't own any other securities, do you, where you have significant capital gains or anything like that that can offset, or capital losses, because it's been a bad year, where you can offset those massive capital gains, do you? Granted, 500 grand capital gains, that's big. She goes, no, I don't. But just know that there are capital loss netting strategies that can take place there. Gifting, absolutely. By the way, folks, when it comes to estate planning, I've gotten this question a lot, and I've done a lot of training on estate planning. You are allowed to gift without any taxes up to 12.0. Right now, the total lifetime gift exclusion, or exemption, technically there are differences, is the same as the estate tax exemption, 12.06 million. And what you gift reduces effectively your estate tax exemption dollar for dollar. So people say, Charlie, so I gift my $5 million property, into some sort of an irrevocable trust, and that reduces effectively my exemption by $5 million anyway. It seems that ultimately I'm taxed, my beneficiaries, my heirs, those that inherit the property, assuming I'm over $12 million, they're taxed the same whether I gift the property now, because that reduces this dollar for dollar, or whether I die with the property. That is not true. That is not, most of it's true, but here is the purpose. Here's what gifting does. It freezes the value of the property gifted. You gift something into an irrevocable trust, which is creditor protected, right? Creditor protected, especially if you get into the offshore irrevocable trusts, which we're not getting into. You gift something into that. What reduces this $12.06 million is dollar for dollar the value today. You have frozen the value of that asset or the liability. If that $5 million property when you die is worth 20 million bucks, that's a completely different scenario. So sometimes it's better to gift it today than to let it grow and then die with it. That's a lot of what estate planning is about, folks. Not going to go into taxation a whole lot. We all know tax rates are going to increase. This is where I'll talk with the consumers about some tax facts. If you look here, debt as a percentage of our economy. Oh, it's okay to be $30 trillion in debt because we're a massive economy. Well, okay. Well, when you compare debt as a percentage of gross domestic product, our economy, we haven't been in this territory, and this is a couple years old here, this statistic here, since the 1940s, right? What happened in the 1940s? Higher tax rates. So I share that with the consumers on this part. David, charitable gifting strategies. Yes, charitable gifting strategies as well. All right. This is fun here. So this is where we get into the nitty gritty for the next 17 minutes or so. The good stuff. We're going to talk about life and annuities as well. Who's vulnerable to lawsuits for reasons I already discussed? Doctors, accountants, CPAs. Do you need a license for this? Thank you very much, Mr. David. Yes. Do you need a license for this? Does it depend on your personal know-how? Are you providing personal services to your clients and professional services to your clients? These are people. Think right now. Do you have people on this list that you have in mind? Oh yeah, my doctor. One of my best friends, people laugh at me. One of my best friends is my GI guy. My wife laughs at me. I had a foot of my colon removed a year and a half ago. I was just brutal on my body with athletics when I was younger. But he is somebody that I am talking to about this, right? Now, what doctors, here's some quick statistics. What doctors are most prone to lawsuits? OBGYNs, 85% of them get sued over their careers. Oh, up here, just in general, a study done by Medscape, 64% of physicians have been sued at least once by 54. You get over age 60, 80% of them have been sued. This is serious stuff for doctors, right? Doctors are told in med school, it's not if you're going to be sued, it is when you are going to be sued. You screw up on a surgery. Surgeries very rarely have the perfect outcome, right? Get out of surgery, you don't feel any pain, all is working exactly the way that you dreamed of it working. No, doctors get sued a lot. When they get sued, like I said, it's as if everybody is an outside creditor, can come after their personal assets when it comes to getting sued in their practice, in doing their work. Now, if they get sued, I use this example, if they get sued because let's say they sexually harass somebody, right? That is not the specialized work, of course, that is the lightning rod to the personal assets. In that case, and maybe that's a bad example, but in that case, for the most part, employee disputes, whatever the C Corp, the LLC or C Corp, that is why you have those, to protect these doctors from it. But the other stuff, you screw up in a surgery, or you, a financial advisor, screw up with a recommendation, that's a lightning rod to your personal assets, except for your homestead. So here's a homestead exemption. Your primary residence is protected to a certain extent, which varies by state. Generally does not apply to foreclosures. Obviously, if you buy a $5 million home, 80% financed, you default on that loan, they're going to tell you to sell, they're going to foreclose on the property. State specific. So for example, Florida has an unlimited exemption. You can have a ton of equity in your house. It's exempt. California is a little more complicated. They say whatever the median price of the house is up to a certain level, $600,000, you are entitled to that, your equity up to that. So in my example here, you're sued for $1 million, but have $700,000 in equity. You can be forced to sell your home. What happens when you sell your home? Well, assuming the median price, as we talked about, the median price of a home in the US, let's call it $400,000. You sell that home, you get that 400, or you're forced to sell that home, you get that $400,000. 850,000 is the median in California, but California, they don't use 850. I purposely put in nationwide median. Nationwide median is what it goes off of. Yes, nationwide. So you don't get the benefit of the higher home prices when it comes to this. You get the $400,000 in this scenario. Technically, it's like 450,000 as a nationwide median, as we talked about. What happens to that other $300,000 of equity? Well, that's what your creditors get. Ownership types. Tenancy in common, joint with rights of survivorship. Tenancy by entirety. This is what we're going to talk about this. For those of you that, especially securities license folks, or have seen a lot of accounts, what does JWROS stand for? That's this, joint tenancy with rights of survivorship. What does TIC stand for? That's tenancy in common. These are ways that you can title property, real estate, also ways that you can title securities, bank accounts, for instance. So what are the differences? How do they apply to asset protection? So the first one is joint with rights of survivorship, also shortened to joint tenancy. This is property. Let's say let's say he's a doctor. My doctor friend from college says, hey, Charlie, let's go halvesies. Let's go halvesies on a property along the lake and let's rent it out. Let's rent out a property on the lake. And this happens a lot. So yeah, no problem. We'll just go into it, title the property with joint with rights of survivorship. What happens? Well, first of all, joint with rights of survivorship, we each own a share of all of the property. 50-50 cannot be different, or if there are three of us, 33%. We all get access to the entire property. Here's the thing though, if he passes away, I get all the property. If I pass away, he gets all the property. That's why people tend to favor this strategy, because no probate, right? It's like a poor man's revocable trust. It's like a poor man's estate plan. But Charlie, you mean to tell me that your family, if you die, it goes to him? You've disinherited your family? Absolutely. But yes. So a lot of people don't realize this. Well, no, that's okay, because in my will, I just put that my doctor friend shouldn't get the inheritance of my share of the property. It should be my family. That's like saying, well, the beneficiary on my life policy, oh yeah, that's outdated. It's my ex-wife, but that's okay, because in my will, I put that my kids should get the proceeds of that. What supersedes what, folks? What supersedes what? Contracts trump wills. Well said. Contracts trump wills. My doctor friend's family gets, or my doctor friend gets my share after I pass away. Another scenario, my doctor friend gets sued with joints with rights of survivorship. To keep this simple, he's a lightning rod over to me. He gets sued. He's a lightning rod over to my property. So what can happen is, technically what happens is the courts can say that the creditors can say, well, the courts and the creditors can say that basically the joint tenancy, it's severed. And what that turns into then is a tenancy in common. In short, the end result of all this is I will likely have to sell my property, his property, because he got sued, and he got sued personally, right? As we talked about. By the way, might it have made sense to set up that property in an LLC, for instance? Heck yeah, it might have made sense. What about a C corporation? What about a C corporation? Remember, they can go over his 50% share of that C corporation and, well, do what we just talked about earlier, right? Okay, so the courts can order the joint with rights of survivorship to be severed. And what happens then is it turns into I owning half, him owning half via our second ownership, tenancy in common. It turns into a tenancy in common. Now, here's what a tenancy in common is. It can be partitioned out. And I'm not just talking about property, real estate. I'm also talking about, oh, one more thing, by the way, a bank account. I just said that the entire property can be shared with joint tenancy, joint with rights of survivorship. What does that also mean? It means when we're talking about assets, securities, real estate, whatever, one person can liquidate the entire account. It only takes the consent of one person. That's kind of a bad preservation strategy, right? But tenants in common is a little different, to where each person owns their own share. When this person passes away, it goes to their beneficiaries, right? It goes to the estate. Or if a revocable trust maybe says, hey, it goes to my heirs, that's what tenants in common do versus, well, this share goes over here. Now, what can happen here is with tenancy in common is the creditors of one owner can petition the court to foreclose on the entire property, to sell the entire property. So funds are made free and clear for that one person for my doctor friend that got sued. That's not good for what I was trying to do, right? Of the three ownership structure, of the two, this is the best one. Tenancy in common generally doesn't avoid probate, but you know what? When you die, it at least goes to the right place. Usually you're not disinheriting your family. You don't have the ability to liquidate the entire account when it comes to tenancy in common, but the best of all three of these is only in spousal situations, and that is tenancy by entirety. It's not in all states. It's in about half the states. The tenancy by entirety says that husband and wife, spouses, can't say husband and wife, just spouses, that no transactions can take place unless the consent of both of them is had. You have to have the consent of both of them. The husband does something, runs into a kid on the street because he was texting and driving. The creditors of that husband, can they get access to that property titled tenancy by entirety? No, only the creditors of both of those people that own the tenancy by entirety. For instance, that property that's owned tenancy by entirety, somebody falls and breaks their neck on that property, they are a creditor for both of those people. And these people that are suing, the family that is suing, has access to the TBE, the tenancy by entirety property, but only in those situations. Now, and not the situations, by the way, to where one person is getting sued of the couple. Now, accidental disinheritance. People are getting married later in life, right? You have a kid here, you have a kid here, step kids now because you got married. If the husband passes away, this property goes to the wife. who is now unrelated basically to the kid, accidental disinheritances, right? This is where irrevocable and revocable trust can come into play. I believe that every client you talk to, almost every client you talk to, as the clients that I talk to, need 3 different documents. A revocable trust. A revocable trust does indeed avoid probate. And by the way, a revocable trust is that's not going to supersede. I misspoke earlier. That's not going to supersede the tenancy by entirety there. Tenancy by entirety property, it's going to the surviving spouse. But I digress there. Revocable trust, one of 3 documents. A pour over will is the second of 3 documents I think almost everybody needs. Why a revocable trust, by the way? Because wills do not avoid probate. They don't. Wills are merely instructions for the attorneys and the judges. Oh, but revocable trusts are too expensive. Main point around probate. Main point around probate. It doesn't really register with a lot of clients when you say, oh, well, it doesn't, wills don't avoid probate, but revocable trusts do. What does resonate is when you talk dollars and cents. Mrs. Client, you have $1 million of an estate. The costs of probate without a revocable trust, just a will, and it will go through a probate, even if you have a will, is anywhere from 3 to 6 to 7% of your estate. You're balking over a $2,000 revocable trust when your $1 million estate after you pass away is going to cost your heirs $50,000 to go through this probate. That is why revocable trusts, pour over wills, which are basically a backstop, in case the attorney doesn't include everything in the revocable trust. The third thing, a durable power of attorney. If you become incapacitated, can't think for yourself, can't make decisions for yourself, a durable power of attorney. 3 documents, partner with an elder law attorney. I have one of the best in the state, one of the best in the Midwest. And I tell you, a lot of business has come from it. So revocable trust, not a good asset preservation strategy when it comes to creditors. Irrevocable trust, for reasons we just talked about, absolutely, because it's a completely separate entity. So get this story. I had somebody call me probably 6 weeks ago. It was a friend's wife from high school. She said, Charlie, I'm not telling my husband, I'm calling you. I'm like, this is an interesting conversation. She says, because he wouldn't want me to call you on this, but here's the deal. My brother needs help. He has a lot of assets, but it's called the Iowa treasure hunt, basically unclaimed assets. He's got like hundreds of thousands of dollars in unclaimed assets. She says, is there anything we can do, like immediately move it from the Iowa fund, the Great Iowa Treasure Hunt, it's called, they call it that, from this unclaimed assets that are rightfully his that he can claim easily into like an irrevocable trust or whatever. Why do you want to do that? Well, I don't know that he really kept up on his taxes. That is called a fraudulent transfer. So when there's a liability happening to transfer this stuff over to irrevocable trusts and businesses while the liability has happened, you can't do that. That's called a fraudulent transfer. That's just a quick story I had with her. Qualified personal residence trust, that's an irrevocable trust, moving property, the household, into an irrevocable trust. Now, business structures. That coffee is giving me the hiccups. Business structures, there are a couple of points beyond what I pointed out earlier. Sole proprietors, no barrier, 0 barrier. The sole proprietor, if you don't have an LLC, whatever, you do something to an employee that they sue, no barrier between you and your personal assets. That is the second worst strategy for creditor protection out there. No barrier. Your creditors get access to your business gets access to your personal creditors. What is the number 1 worst? Partnerships. Again, no barrier. It's just that you have this, what would you call it? Maybe a loose cannon as a partner that is also subjecting you personally to risk, his behavior, right? We talked about how corporations are good for asset protection. We talked about how limited liability companies are very good for asset protection. Now think of this, folks. Think of this. Think of quarantining your boat. That's a liability driven product, right? With your securities, very safe product, quarantining this stuff off within little limited liability companies. Think of that strategy. There are limited liability companies that are multi-member limited liability companies, maybe in the state of Nevada, for example, to where the only remedy to get access to those assets in the limited liability company is called that charging order that I referred to earlier, which is where you don't get, the creditor doesn't get the income. They just get the tax bill, right? Limited liability companies, they're paramount when it comes to asset protection. Now, I mentioned this, corporations or LLCs for that matter, don't provide personal liability exposure for personal services. Let me ask you a question. Would you put your home, your homestead within a limited liability company? Would you do that? Would you put your home within a limited liability company? The answer to that question is generally no. Why? Because you have the homestead exemption I talked about earlier. But number two, there's a reason I prefaced all of this with this stuff. $250,000 exclusion from capital gains, or if you're married, $500,000 exclusion. Do you get that if it's owned by a company? You don't get that, right? So there are certain things you pick and choose, quarantine off, but your home is generally not one of them. All right, so I'm gonna end after this slide here. Here's the thing, is you have various assets out there, qualified retirement plans. We talked about taxes. Unless there is a Roth IRA option in that 401k plan, for example, it's usually not tax protected. What about creditor protected? Qualified retirement plans, absolutely. Usually it's subject to market volatility. You go down the list here, and there are two I want to point out. Cash value life insurance, tax protected. Yes, you are paying taxes on the seed versus the harvest, Mr. Doctor. You are paying taxes on the seed versus the harvest. But not only that, that cash value, as well as the death benefit, generally, depending on the state, is protected should you be sued by one of your patients, right? Annuities, it's the same thing. Doesn't have the same wonderful tax treatment, but it's generally the same thing from a creditor protection standpoint. And yes, there are ways we could protect those assets in the annuity and the life insurance from market volatility as well, because they automatically, in most states, and I have a ledger here, message me if you want to know the details based off your state, but they automatically in most states are creditor protected. Folks, I've gone over here as usual. Please fill out the evaluation as I talked about, a toned down, more simplified version of this. Would you like me to do this for your clients? As well as just give me general feedback that you're going to see in the evaluation here in about 10 seconds. Thank you for your time. By the way, folks, get appointed with CG Financial Group. If you like this webinar, why not, right? My phone number directly to my office is 515-986-3065, and you have an evaluation that's popping up right about now. Talk to you guys later.